We don't know what they're going to come out with. It looks like later on this year, won't go into effect till sometimes next year. But do we think basically they're going to cut back on some of these reserve requirements?
That is certainly what it looks like right now. Powell has said on multiple occasions that we should expect broad and material changes. Again, this is not just the Fed. The Fed has to work closely with the FDIC and the OCC, but it certainly looks like what we're going to end up with is a very different suite of reforms than those that were proposed about a year ago.
So there are specifics with regulation like this that's come down the pike, and we'll find out where it ends up. But we also had a pretty momentous, I think, term of the Supreme Court when it comes to regulation. Not necessarily involving bank regulation, but about regulation overall. Particularly the thing that people are focused on is Chevron. The overturning the Chevron doctrine in which the courts would defer to the agency's interpretation of the statute. Could that affect banking regulation as well?
It certainly could and will. I mean, if you look back historically, Chevron was actually one of the key vehicles that facilitated deregulation during the 1980s and 90s. So as you just said, the core idea of the Chevron doctrine is when a statute is ambiguous, that's going to be treated as a delegation to the relevant agency to figure out the best interpretation under the circumstances that they're facing using their expertise. And so in the 1990s, that was a mechanism through which they said, look, banks can actually engage in a far broader array of activities than we previously thought. In the short run, I think banks are celebrating this as a win. Business is celebrating this as a win. Longer term, it's really hard to know. It really creates a lot more legal uncertainty. It does reduce the relative certainty regulators are going to have regarding whether or not the rules are going to be respected. And it puts courts in the driving seat in a way that I think could really shake things up.
So I'm going to ask you do something you're not going to want to do, is just speculate, but we don't know. But you teach regulation and legislation with respect to particularly financial institutions. As we look at various regulations that are pending, including the Basel III, but not limited to that right now, do we think that that may affect the way they go about making their rules? Because now they're very conscious of the fact they're going to have a court of some sort looking over their shoulder right quick.
Yeah, so two things. One, I think it's certainly going to affect the way that they undertake rulemaking, Basel III, and otherwise. That's partly because, again, Loper Bright just overruled Chevron, but there were also a number of other significant Supreme Court decisions that really allow courts to scrutinize far more closely the decisions that regulators are making and the processes through which they're making those decisions. So there is a risk it's going to make regulators a little more gun shy and a little more worried about making sure they've crossed every single T and have dotted all of their I's before they promulgate a regulation. That being said, bank regulators are also bank supervisors, and they have an ongoing duty to really promote the safety and soundness of the institutions that they oversee. So you could end up with a world where if regulation is not able to keep up with potential changes in market dynamics or risks that supervisors are seeing, a lot more work gets done through that supervisory process, which is far less transparent and far less uniform.
Well, so this is a fascinating point I had not really thought about. It may shift away from the regulatory approach where they have a notice and comment, everybody comments on it, we know what's going on, as opposed to, I'll call it prosecutorial discretion of a sort, through the supervisory function. That's a very different kettle of fish.
It is a very different kettle of fish. It's one banks have had to deal with for a long time, but the question is relative importance. One of the ways of understanding Chevron, particularly as it's been narrowed in recent years, is it created a real carrot that really encouraged regulators to undertake notice and comment rulemaking, which is a very time-consuming, very resource-intensive process, because at the end, they knew they were going to get this carrot called Chevron deference. Now that you've taken that carrot away, it puts a lot more onus on the regulators to think, well, what is the right tool of the various tools I have available for trying to achieve a particular end? It still might be regulation in some set of circumstances, but it could also be supervision. For banks, it could be things like the living will process that we've seen being a mechanism through which you get kind of change over time. It could also, for something like the CFPB, be policymaking through enforcement. Rather than clarify what certain terms mean, use enforcement policy be a mechanism through which you make policy. So again, I think it certainly changes the world around regulation by rulemaking, but that doesn't mean long-term it's really a win for business.
And finally, Professor, we now are into the earnings season for the banks, and we started with the big banks. I wonder about unrealized losses, particularly from some of those treasuries that are standing out there, which may not be so much of an issue for the really big money center banks, but is much more for the regional banks, as we saw, for example, with Silicon Valley Bank. Do those unrealized losses have to get realized at some point? What effect could that have on the overall system?
Yeah, I mean, so this has been a challenge that, again, took people off in an unexpected way in spring of 2023. SVB and Signature were really messy failures that required extraordinary measures by the FDIC and other financial regulators. That being said, at this point, everyone sees it's coming. Everyone's paying a lot closer attention. So I don't think we're going to see the same type of disruption. Whether or not they're going to realize them, I mean, again, partly it's a question of accounting. What is the bucket in which banks want to put these instruments? They're going to have to pay more attention to them for regulatory purposes, even if not for financial statement purposes, because of changes underway. But again, the real key for a bank, generally speaking, is you're using deposits which are nominally short term, but in practice, in most states of the world, are really sticky and long term to fund longer term assets that include treasuries, but it also includes a lot of loans. And so there's reasons that we allow banks to hold these instruments, and for banks to think that, at least in most states of the world, they're going to be able to hold them to maturity. We just want to make sure that banks are really managing the duration risk associated with their operations.